the sponsor of the bill and Subcommittee Chairman Burlison from Missouri.
Thank you, Mr. Chairman. Members of the committee, I'm here to urge you to support the Guidance Clarity Act, H.R. 2409. This is a bipartisan bill. It ensures transparency and fairness by requiring federal agencies to clearly state on each guidance document, and I quote, "The contents of this document do not have the force and effect of law and do not of themselves bind the public or the agency in any way. This document is intended only to provide clarity to the public regarding existing requirements under the law or agency policies." This bill is about clarity. Agency guidance plays a vital role in helping the public understand how agencies interpret law and policies. But too often the agencies abuse this tool. They issue guidance that intimidates small businesses and individuals into compliance, sometimes under the threat of enforcement. Many lack the legal resources to know what guidance is not, that it's not binding, and they feel forced to comply with what's merely an agency's opinion. How is that transparent or fair? This bill will fix this. It's also about accountability. Agencies have been known to skirt the Administrative Procedures Act requirements for issuing binding rules by slipping so-called non-rule rules into guidance documents. Courts have struck down these tactics, but the problem persists. During President Trump's first term, the Justice Department took steps to prevent enforcement based on guidance alone, but those protections were rescinded under President Biden. The threat of abuse is real, and it undermines the trust in our government. The Guidance Clarity Act closes it by ensuring that guidance cannot be mistaken for something that people that were actually elected, lawmakers, passed as law. Finally, this bill is about protecting small businesses and ordinary Americans who often can't afford legal teams to challenge agency overreach. They deserve to know in plain language that guidance is just that, guidance, not a mandate. This bill empowers them to push back without fear of unfair enforcement. Members of the committee, this is a straightforward solution to a real problem. It promotes transparency, upholds the rule of law, and protects those who can least afford to navigate the bureaucratic overreach. Last Congress, the Oversight Committee favorably reported an identical version of this bill. And let's build on that momentum, and I urge my colleagues to support the bill. Thank you. I yield back.
Gentleman yields back. Thank you for your leadership, Mr. Burlison, on this bill. Chair recognizes Ms. Norton from Washington, D.C. Sorry.
Thank you, Mr. Chairman. I yield to Mr. Lynch.
I thank the gentlelady. Let's be clear. I mean, if you really think that this is a clarification by putting this statement on each guidance, have you ever taken a bill that we pass and try to read it? Especially when it refers to maybe a half dozen other bills that we have passed in previous Congresses? It's complete gobbledygook when you read the statute. When you read the statute, it is totally confounding. You can't put 5 sentences together to come up with a lucid thought when you read it. To suggest that a business owner, a small business owner, Mr. Chairman, would go to the statute and try to figure out what the hell Congress intended is lunacy. Look at some of the bills that we pass here. Read the text. It's completely incomprehensible. It doesn't make sense at all. The guidance is there as a synthesis of what congressional intent is on that piece of legislation. It actually helps to translate the complex, legalistic, statutory language that Congress has enacted. It allows that small business owner to act in compliance with that statute. And I totally get the gentleman's point that sometimes a particular agency might go afield of the guidance or might misstate the guidance. And we challenge that on occasion when we believe that congressional intent is not being followed, that becomes a matter for the courts, because they read the statute, they look at the guidance, and sometimes, which happened recently in financial services, there's a direct order to modify the guidance. That's what they did with the SEC. They changed the guidance for banks on cryptocurrency. So I get the spirit of the gentleman's bill, and it's been here before. I think Mr. Palmer was a sponsor in previous Congresses. So I get that. But to disavow or to discount the value of that guidance, I think, creates great confusion. It undermines the rule of law. It undermines the rule of law. It does not assist the rule of law or clarify the rule of law. It creates confusion and doubt in terms of how we conduct ourselves in this society, right? The laws in this country are the software of our democracy. It embodies rights and ideals and provides recourse for those who feel that their rights of freedom, the freedom to contract, private property, all those elements that make us Americans. This would be corrosive, I believe, to that effort to maintain the rule of law at a very time when we need it so desperately. You know, as members of this committee know, you know, we, in our oversight responsibility, we travel frequently to failed states, whether it's Afghanistan or Iraq or Somalia. We've been to all those places time and time again. And one of the common elements of a failed state is that they lack an adherence to the rule of law, and in many cases they lack an independent judiciary. So I think this type of confusion, of diluting the force of law by dismissive language on guidance will harm adherence to the rule of law. It will damage the respect for the rule of law by adding frivolous language to the guidance that means to interpret that very law. With that, Mr. Chairman, I yield back.
Gentleman yields back. Do any other members wish to be heard? The question is now on the amendment in the nature of a substitute. All those in favor signify by saying